Welcome to the first panel, State of Play and Emerging Trends of Corporate Climate Litigation Across the Americas. So this first panel is in a way the introduction to this conference in terms of the knowledge that we have in the different legal system, because we have gathered together the rapporteurs from Brazil, from Canada, with joining us online, and our colleagues from ELI are going to play as our US rapporteurs, even though the rapporteur from the US is Michael Manning, our co-organizer, and the co-writers of this report that you find on the website is Lisa Benjamin, and a professor from she's a professor in the US. So yeah, this will be let's say is a patchwork of people that have been working on the US part, and it's great to be in ELI because in a way we are going to have also people that are working in practice in this area. So let me just introduce with the first speaker, with Jarryd Page. He's a staff attorney at the Environmental Law Institute, where he works at the intersection of climate change, policy research and education. And he brings experience in domestic and international environmental law and policy to his work on the Climate Judiciary Project, public lands management, and coastal resilience. And Jarryd also written and lectured widely on climate litigation topics. He's been published in different law journals like Harvard Environmental Law Review and the Georgetown Journal of International Law. He's also the co-author of a forthcoming book chapter as Health versus Montana, which is, as you know, a very important case here in the US. And he received a JD with honors from George Washington University Law School here in DC. And Jarryd, I will just leave you the floor to you, and thank you very much for everything, also for organizing this.
No, of course. So thank you all for joining. Delighted to be here today to talk to you about sort of the US perspective in terms of where we are and emerging trends. Some of this will have just been covered by Professor Mike Jarryd, but I hope to give a little bit more detail in a couple of these areas. And I think you'll hear some additional detail in other areas about US corporate climate litigation in forthcoming panels. So as Ivano said, my name is Jarryd Page. I work at ELI as a staff attorney, and I work a lot on our Climate Judiciary Project, which trains judges about climate science impacts and solutions, and how that climate science arises in the law. We are a research and education organization, so we don't tell judges how to rule in any particular case. We don't tell them how to rule on any particular issue. We provide them factual information in order to help them make the best decisions possible. So you just saw this slide a minute ago in Mike Jarryd's presentation, but I just want to sort of linger on it a minute. This is really the most definitive and best place to go for information about climate litigation generally, and especially corporate climate litigation. There's two databases here. There's a US database and a global database. They are very user-friendly. You can search them. You can filter them by jurisdiction, by year, by claim. And they have descriptions of the cases and links to a bunch of different documents within each docket. And so if you haven't visited this resource, I'd encourage you to. This chart shows the number of climate cases by year filed. This graph represents all climate litigation, not just corporate climate litigation. But I sort of have marked out a couple areas where I think the BIICL National Report does a really good job of sort of breaking down corporate climate litigation in these waves. And so, you know, the first wave starts in, you can see 2006 and lasts until about 2012. And that wave was really that first AEP versus Connecticut wave, where plaintiffs were bringing cases against corporations based on federal common law. A lot of these cases in this early wave were dismissed on political question or on preemption grounds, like the AEP versus Connecticut case was. The second wave actually sort of starts after the AEP versus Connecticut case. Federal common law sort of gets closed off as a door, and plaintiffs start bringing cases based on state common law. And that second wave really starts getting going in 2017. And we're still seeing that wave take place. And a third wave of corporate climate litigation is sort of separate. It started in 2015. And that wave really represents a broad diversity of claims that are being brought. So sort of beyond the federal common law and the state common law cases, you're starting to see a much greater diversity of theories. And so I'll show you what a few of those are here. I think I just want to make one more comment about this slide before moving on. It relates to this asterisk here. You heard Mike Jarryd say there's already over 3,000 cases that are in this database. And I'd like to just sort of note that I believe this is like undercounting the degree to which climate change is impacting courts. One, because it's not always difficult in terms of collecting data to find out where cases are, especially at the local and state level. And the other reason is the definition that you need to meet to be a climate case and make it into this database. Says that climate science, policy, or law has to be a central or material issue to the case. And there's many cases to which climate change is relevant, but not necessarily a central issue. You can think about a lot of cases following climate impacts, like thousands of insurance claims and cases that are filed after a hurricane, for example. The database similarly doesn't capture some permitting cases, for example, like a fossil fuel fired power plant. If climate isn't a material issue in the case, it's not captured in the database, even though, of course, the outcome of the case has some relevance for mitigation or adaptation. So just sort of keep that in the back of your mind. So this is a chart you just saw a minute ago, and just to sort of highlight the fact that I don't think there's any one typical climate case. Climate cases, again, it's sort of in general, they implicate a wide variety of legal theories. There's constitutional, statutory, regulatory, administrative, common law cases, and that range of cases and theories is reflected in the corporate climate litigation category as well. I've sort of highlighted a couple of pieces of the pie. These are a couple that Mike Jarryd called attention to. The common law claims and the other state law case categories is where you can find a lot of the corporate climate litigation. But the other categories can be relevant too. As Mike Jarryd said, there's NEPA cases and there's Clean Air Act cases that involve corporate defendants. So one thing I really like about the BIICL national reports is they try to provide some level of consistency among the national reports. And so here are the types of claims that are, I think, studied for each one of the national reports. And so I'm not going to walk through every single one of these 9, but I want to touch on a couple of them and highlight a couple areas where I think, again, we are at with the state of play or emerging trends. One is environmental law. So the United States doesn't have any overarching, climate change act or climate act. And so a lot of cases that are brought under environmental laws are brought under media specific laws like the Clean Air Act or Clean Water Act, Endangered Species Act. The federal common law, right? This we already touched on. This is like the American Electric Power case. Not really seeing any more cases brought on this theory because of that Supreme Court case. What we really are starting to see more of is cases in that central bucket, tort law, and then over to the right as you're shifting in this chart into consumer protection and fraud laws. And one thing I'd say is even though these boxes are showing up as discrete, items on the screen, there's a lot of interplay between these legal theories, and many cases bring claims on more than one of these boxes, right? So a case might bring a consumer protection claim and a tort law claim and a fraud, right? So there's a lot of interconnection between these two. The fraud cases, that includes things like greenwashing, which I think are becoming more prominent, and I'll say a word about those in a second. The human rights law cases, I think these are interesting, and I know Christine will talk a little bit more about these this afternoon, right? The US, even though we may be signatories to some of the treaties you saw on the map, we don't have the sort of robust human rights framework that a lot of other countries have. And so this is sort of a disconnect, I think, between a lot of the emerging trends in other jurisdictions where you're seeing a lot more cases brought on human rights theories. And that's not necessarily the case in the United States. I do want to say one thing about environmental rights amendments. So Mike Jarryd said, we don't have a right to a clean and healthy environment in our federal constitution, but there are a handful of states in the US that have rights like that in their state constitutions. And so these environmental rights amendments, or green amendments as they're sometimes called, are increasingly being seen as a hook for litigants to bring cases. Most of them so far have been brought against governments, that the government of a particular state isn't doing enough. That's the Held versus Montana case that Ivano mentioned a second ago. But I will call your attention to one case that's reported in the report, and that's out of Hawaii. And Hawaii is a really interesting state. One, they do have a constitutional right to a clean and healthy environment. And that was relevant in a case that was looking at an agreement for a biomass power plant to provide power to a utility. And that case went up to the Hawaii Supreme Court, and the Hawaii Supreme Court said that the Public Utility Commission that was reviewing the agreement didn't look enough at the greenhouse gas emissions implications of approving that biomass plant. And the Hawaii Constitution, which guarantees a clean and right to a clean and healthy environment, requires a more robust analysis. And so you are starting to see some movement in this area, but I do think those are sort of rarer examples in the US. The company and financial laws, I think, is an increasingly important area, especially as you move into the third wave. So these are cases brought often by shareholders alleging a sort of a breach of a fiduciary duty, suggesting that the investments that are made on their behalf, investments in fossil fuel companies, for example, aren't in the best interests of the investor, for example. And many of those cases are ongoing. Just want to talk specifically, I have 2 slides on this. Tort law is really where you'll find the bulk of the information in this report. And so I think there's about 10 different types of tort law claims that are being brought in these cases. On this particular slide, I want to highlight some sort of splits that are happening. And so in the public and private nuisance category, you've seen there's been one federal court of appeals who's come out one way on this issue, and one federal court of appeals that's come out the other way. And so in the city of New York for Chevron case, the Second Circuit US Court of Appeals found that those state law claims that were brought, they were brought in federal court, which sort of makes this city of New York case a little different than a lot of the other second wave cases that were filed with state law claims in state court. The city of New York court found that these claims were preempted, and the case was dismissed. The San Francisco Bay cases, that's the city of Oakland and the city of San Francisco, those cases were not preempted. And so those were allowed to move forward, and those sort of represent a circuit split. The US Supreme Court has so far declined to get involved in any of these cases, and so we'll see if that continues to hold true. And I just want to also mention the split in this little blue box here on the negligent strict liability or failure to warn. Again, just suggesting that these cases don't allege only one of these claims, and often, many claims are included in one particular complaint. I'm just lifting up a couple of cases within each category there. So the mayor and city county of Baltimore and the board and the county commissioners of Boulder County, both of these are second wave cases. So that means they were brought by cities, states, municipalities against fossil fuel companies based on state law claims and filed in state court. And now that, you know, the Supreme Court has sort of declined to get involved in the jurisdictional question about whether or not federal courts or state courts are the right venue, you're starting to see many of these cases proceeding back in state courts, right? Mike Jarryd mentioned the one in Massachusetts might go to trial soon, and the Hawaii one maybe sort of shortly behind it. So state courts are starting to rule on the various motions to dismiss in these cases, which are sort of the first opportunity, the first hurdle that plaintiffs have to get over. And the the Baltimore case, we'll just call it the Baltimore case, the state court judge in that case did grant defendants' motion to dismiss. And so that case has been dismissed. It's appealed and undergoing appeal in the state appellate court. But in contrast, very similar case, very similar set of claims in the Boulder County case, the Colorado court denied the motion to dismiss in that case, and it is moving forward. And so what we're seeing is sort of a variety of approaches by these state law or by these state courts into how to handle these cases. And I've got a slide here in a minute that'll sort of show you an update about that. One more slide on the tort law, though, just to sort of note that I think these conspiracy claims are an emerging trend, right? Things like RICO claims or racketeering claims, that this is sort of a broader effort. There's something bigger going on here than just the actions of one particular actor at one particular moment. Boulder County is an example of that, as well as a couple of cases in Puerto Rico. And Puerto Rico is sort of also a hotbed of climate litigation. There's several cases that are pending there. I'm actually going to skip over this slide in the interest of time here. So let me just show you this update here. This is the sort of patchwork of decisions that are coming out of state courts on those motions to dismiss. And so there've been, you know, a dozen or so of these, and the majority of them have had the motions to dismiss denied, but there's quite a few who've granted the motions to dismiss. And so these cases are still continuing to make their way through state courts, and all decisions sort of that everyone in this area will be watching closely. And so I think this is really the next sort of pieces on the horizon are what are happening in the motions to dismiss in these cases, and you know what's happening after them. So I'll wrap up here and turn it over to Ivano.
Thank you very much, Jarryd. So, and you managed to also give another very interesting overview of what we have there. And yeah, it's true, the report from for the US by Lisa Benjamin and Alexander Guillot is really well done, and I encourage you to read it because it's a valuable resources. We just go to the second speaker who is online with us, joining with us. Hassan, are you there?
I'm here, yes.
Perfect. So Hassan Ahmad is an assistant professor at Osgoode Law School in Toronto, where he researches and teaches on topics related to corporate governance, business human rights, transnational law, tort law, international law, and climate change litigation, of course. And prior to joining Osgoode Hall, Professor Ahmad was an assistant professor at the Peter Hallard School of Law at the University of British Columbia, and his research has been recognized by a number of prestigious scholarly organizations, and is the co-editor of the forthcoming Cambridge Handbook of Litigating Business Human Rights, and is, of course, the author of the Canadian report for the Toolbox project. So, Hassan, thank you very much for being with us online, and the floor is yours.
Thank you very much, Ivano, and thank you everyone who organized this and for having me. My apologies, I wasn't able to join you in person and you know, be a part of this wonderful event. Some of what I'm going to say is going to echo what's been mentioned in the American context, both by Professor Jarryd and also what Jarryd talked about right now with regard to some of the US claims, and then some of it is distinct to the Canadian context. So let me go through that. I did want to divide my presentation between three different topics today, looking at some of the trends that will implicate Canadian corporate climate litigation, some of the doctrinal opportunities that will be available to litigants, again, which overlap with the US, given that we're also a common law system, and then look at some of the doctrinal challenges that are there. So, there we go. Okay. So as Ivano mentioned, I authored the Canadian report for the Institute's Global Climate Change project. So that's online there. The report goes into far more details about the causes of action. I'm going to just discuss a few of them and some of the challenges. It also goes into the various procedures that are available in Canada, again, much of which overlap with other common law jurisdictions, whether it's the US or the UK. And then the last part of the report looks at the remedies that are available, again, which are not unknown to people who come from common law jurisdictions. So, okay, let's start with the trends. So, distinct from other jurisdictions, whether it's the US or even the Netherlands, so Milieu Défensif has been brought up by the speakers today. We don't per se have what I would call a global corporate climate case in Canada yet. We don't have anything akin to a Milieu Défensif. So much of what I'm going to be saying is going to be perspective of the doctrines and the legal principles that may apply, but we don't have a case like that yet. What we do have in Canada is an agenda-like case against the government. Actually, we have a couple of them right now. We have one, Mathor, against the Ontario government, looking at the rollback of climate mitigation efforts that were undertaken by the most recent administration in Ontario. Now, that case brought a constitutional challenge under Canada's Constitution. Particularly, we have something called the Charter of Rights and Freedoms. So that case was brought pursuant to a contravention of Section 7 of the Charter, which is contravention of rights, a contravention of life, liberty, and security of the person. The other part of that claim was an anti-discrimination claim. So we have Section 15 of the Charter. So it was a claim brought against the Ontario government that the rollback of climate mitigation efforts disproportionately harmed younger and future generations, similar to claims like Juliana in the US, which are youth-led climate lawsuits. So that's Mathor, the case against the Ontario government. It, by and large, was dismissed, even though there were some redeeming statements by the lower court in Ontario. It was dismissed by the lower court. And likewise, recently, it was dismissed by the Ontario Court of Appeal. I will tell you that the plaintiffs, the youth plaintiffs in Mathor have sought leave to appeal, or what you would call in the US certiorari, to Canada's Supreme Court. So we are waiting a decision from the Supreme Court on that. Briefly, I will say the other claim, the other climate case against the government has been brought against the federal government. Now, different than Mathor, LaRose, which is the claim against the federal government, has not been brought pursuant to any particular piece of legislation or particular government conduct. By and large, LaRose is an argument alleging that the federal government in Canada has not adhered to its climate targets under the Paris Agreement. Now, this case as well has been brought pursuant to the Charter of Rights, so again, Section 7 and 15, but also pursuant to something that hasn't been brought up today, which is the public trust doctrine, which I know is a part of certain state constitutions in the US. The right to a clean and healthy environment is not per se something that is outlined in Canada's Constitution, but the common law doctrine of the public trust doctrine in the common law has been argued in previous cases. It has implicitly been acknowledged by the Supreme Court of Canada in an environmental case about 20 years ago. So that has also been argued in LaRose. Nonetheless, LaRose, like Mathur, was dismissed by the lower court, by the lower federal court in Canada, and also dismissed by the Federal Court of Appeal. So it is hasn't really moved forward on the merits yet. So both of these cases, again, against governments, why I bring them up is like the Urgenda case in the Netherlands that provided legal principles, what we would call horizontal effect, provided human rights principles that then applied in milieu défense. The success of cases like LaRose and Mathur can have potential implications for corporate climate litigation in Canada using human rights principles, using what we call in Canada charter values. The values that come out of human rights law can potentially have some currency in claims against corporations. There have been claims against corporations brought pursuant to environmental harms, similar to the US, the UK, and other jurisdictions. We had claims against car manufacturers. We had the Dieselgate scandal in Canada, just like you did in other jurisdictions as well. We've had claims against deforestation companies. The claim I mentioned about that involved the public trust doctrine concerned a deforestation a dispute around deforestation. We've had other environmental claims, both within courts, but also in tribunals against corporations, but we have not had, as I mentioned, per se, a climate-related claim like you have in Urgenda and in other jurisdictions where the claim is writ large that corporations, one or more corporations, have not done enough to mitigate their climate impacts. Okay, so I mentioned this about Mathur. I'm gonna skip over this to get into what I see as the opportunities, similar to what Jarryd talked about. The opportunities really come out of the various causes of action, both statutory and the common law causes of action that exist or can potentially be argued in Canada through an expansion of current, whether it's tort law principles, whether it's equitable principles like unjust enrichment. Where I will start, though, is something that arguably is unique to Canada. In the US, you've had, for a number of years and decades, you've had alien tort statute litigation, not necessarily in the climate context, but in the human rights context, which has largely been dismissed and negated through various Supreme Court decisions. And the argument is that customary international law can actually form a tort claim that can apply to corporations now in Kiobel, in Jesner, in Nestle. This has been dismissed by the US Supreme Court. We did have a case in Canada, though, Nefson Resources Limited and Araya, that in theory allowed for this kind of claim, this kind of argument to be pursued against corporations. The idea that customary international law, particularly international human rights law, provides fodder for tort claims against corporation was implicitly allowed by the Supreme Court of Canada. Now, I will say that, in the 5 years that since Nefson has been decided, it was decided by the Supreme Court in 2020, there has not been a lot of uptake when we look at whether it's human rights litigation or even climate litigation. There hasn't been any uptake yet on using the theory that was implicitly allowed by the Supreme Court in Nefson and applying it to human rights or environmental claims. But nonetheless, the theory is there to be potentially used in corporate climate litigation. So that is something that is somewhat unique. That I do not believe there's been a Nefson-like decision in other jurisdictions around the world. The other opportunities I see, as Jarryd mentioned as well, really lie in traditional causes of action in tort law, whether it's trespass. Now, trespass does not require, in the common law, trespass does not require harm, but with that, the damages awards that have resulted from trespass claims, whether against corporations, whether due to environmental harms, have been relatively, in Canada at least, have resulted in lesser quantum of damages than other causes of action. Other than trespass, the main, and I'll get into public and private nuisance in a moment, but one of the other main causes of action lies in negligence. Negligence law works similarly to the state law of negligence in the US, but also in other common law jurisdiction. It's developed in much the same way. There are certain idiosyncrasies, obviously, to the Canadian story of negligence, but ideas around the duty to warn, negligent misrepresentation, and also just general negligence claims are similar in Canada as they are to other jurisdictions, and therefore the barriers that result around these types of claims are similar as well. I'll get into some of those when we look at ideas of causation or standing, but one that I'll mention here is establishing proximity, this direct connection that is required under Canadian doctrine between the alleged tortfeasor and the victims. That is something that is difficult given the attenuated nature of greenhouse gas emissions, and connecting that to particular plaintiffs can be difficult in a negligence claim. Let's go back. They're again not necessarily in the climate context, because these kind of claims have not been brought yet, but in environmental claims there is some precedent that can be relied on. I have the Burgess decision up there, but all in all, there are minimal legal principles out there, so this is somewhat of a risk part, and that might be in part why we haven't seen corporate climate cases in Canada, because these are risky cases to bring. Distinct from the US, we do have a loser pays system when it comes to costs in Canada, so there is more risk involved. We also have third-party litigation funding. We have some government funding when it comes to covering costs for civil litigation, but these are risky cases to bring, and the doctrine remains ambiguous and has not been tested yet. So that might inform in part why these cases have not been brought in Canada to date. Nonetheless, we do have, both on the negligence side of things, but also on the intentional torts, we have ideas of fraud and fraudulent misrepresentation. We have torts that have to do with conversion and assault and battery, all of which contain principles that could potentially be used in corporate climate litigation. But like I said, these causes of action were not traditionally formed for the widespread and attenuated nature of corporate climate impact. So there are a number of risks, doctrinal risks at least, in terms of trying to fit in these traditional causes of action into the novel fact pattern that climate change presents. I mentioned public nuisance. Public nuisance, when it comes to mass harms, has been utilized both in the environmental context and otherwise. So it's been defined by Canada's Supreme Court as any activity which unreasonably interferes with the public's interest in questions of health, safety, morality, comfort, or convenience. So the idea of substantially interfering with the health and well-being and the safety of Canadians, that definition can, again, in theory, play a role in corporate climate litigation in Canada. So the two basic requirements in the Canadian doctrine is that there has to be a substantial interference with your use and enjoyment of public property, and that interference has to be an unreasonable interference. So it's not, the Canadian case law makes it clear it's not the conduct per se. So for instance, fully legal and reasonable construction projects, because courts have determined them to result in unreasonable interference with people's businesses, with people's reasonable enjoyment of public property, those types of cases have been successful on public nuisance grounds. So again, it's not the activity per se, it's the interference the activity has with people's daily lives. So public nuisance can, again, in theory, form a part of corporate climate cases. Similarly, private nuisance, relies on similar principles, but it has to do with the use and enjoyment of one's own land. So we have ideas around toxic torts in Canada, similar to other common law jurisdictions. Okay, I won't stay on this for too long, but in the literature around corporate climate litigation and climate change litigation, there's this idea of stealth litigation using these niche areas of law, whether it's consumer protection laws or planning and permitting laws, to go after one particular act or conduct or project. But in doing so, you can have these ripple effects on how corporations make decisions that will ultimately have an impact on the climate. So we have this idea as well in Canada. And again, there hasn't been a great quantity of these cases brought in Canada, but there are certain examples that we can point to. Again, not bringing a case that directly implicates climate impacts, but potentially implicates a potential project or an act or course of conduct that can have ripple effects on climate change. And then lastly, I mentioned the public trust doctrine that's been brought up in LaRose. The public trust doctrine can, in theory, also be used by governments to bring claims against corporations. This is what the Supreme Court, again, implicitly, not directly because it wasn't a case about climate change, but the Supreme Court of Canada implicitly endorsed this kind of approach. So the idea that whether it's provincial or federal governments bringing claims against fossil fuel companies, against companies in the extractive sector, this has been utilized, I will say, and is being currently utilized in other areas of litigation, whether it's opioids litigation, tobacco litigation, and we also have novel litigation against social media companies in Canada. So not per se the public trust doctrine that is limited to the protection of natural resources, but the idea that government in their parents patriae standing can bring claims against corporations on behalf of the public. So again, that approach and that theory could be used in corporate climate litigation in Canada. I'll just say this quickly. We don't have a federal securities regulator in Canada, but the idea of having more expansive disclosure laws and that being used in whether it's negligence or public trust or customary international law claims is an approach that can be taken. And lastly, using the theory that was brought up in Client Earth in the UK, not going after the corporate person per se, but going after the directors and officers of a corporations for the decisions that they've made that ultimately have climate impacts. Okay. The challenges, the doctrinal challenges, again, are going to be similar as we see in other common law jurisdictions. The first relates to standing. Who can actually bring these claims? This was an argument that was brought up in the youth-led claim against governments. I know it's been brought up in Juliana and the atmospheric trust litigation in the US and also in other parts of the world as well. Who has standing to bring these claims against corporations, especially when corporate climate impacts, greenhouse gas emissions really affect everybody, not necessarily in the exact same way, but there is this global effect felt by the entire population. We do have notions of public interest standing in Canada where an organization or a particular plaintiff can stand in place of a group of people, represent their rights and arguments before a court. There is a three-part test the Supreme Court of Canada has laid out that has to be fulfilled. And really, the way the case law has shaken out is that it's the third prong there, convincing a court that there's no other reasonable and effective way to bring the case before courts, that you do need a litigant that has public interest standing, that is standing in the place of a group of people. That's really been the tension in public interest standing. All of this said, standing doesn't appear to be the major issue in the Canadian doctrine when it comes to climate change litigation in general, but putative corporate climate litigation as well. I think standing is something that can be overcome, given that we do have expansive notions of standing in Canada. Statutory defenses. I know this this arose in the recent Supreme Court decisions around climate litigation in the U.S. as well. The idea that you can preempt claims because there are statutory defenses. You know, it's rich of plaintiffs to say this is the argument that corporations make. It's rich of plaintiffs to say that corporations should be held accountable for their climate impacts, when that's exactly what they've been incorporated to do. That they are just conducting the business that they have received their charter of incorporation to conduct. So there are statutory defenses, both extractive industry companies, but also companies in other sectors have utilized these arguments, sometimes successfully so. Justiciability, what you would call in the U.S. the public question, or the political question doctrine. The idea that a global impact, a widespread impact on the population is better dealt with by the political branches of government, whether it's through legislation or executive orders, rather than the judiciary, which is meant to hear discrete disputes among particular parties for particular conduct. Just the global nature, the fact that climate change, as I mentioned, affects a large swath, if not the entire population, rather than particular parties, suggests that it's better dealt with, that it's not best dealt with by the courts. This was an argument brought up in the climate litigation against governments in Canada. It was dismissed in Mathor because there was a particular piece of legislative action that was being challenged. It was ultimately successful, as well as other arguments in the LaRose case, because LaRose, as I mentioned, was not brought pursuant to a particular piece of legislation or conduct. It was just saying, in general, Canada's government hasn't done enough. And the court said, well, that's better addressed by the legislative branch of government. So justiciability, likewise, will likely be a barrier when it comes to corporate climate litigation. Okay, I know I just have a minute or two left, so I will wrap up. Causation, when we look at particularly the tort law causes of action, establishing what in Canada we call both factual causation. Did A factually cause B? Courts are able to make what's called an adverse inference, but that is an exception rather than the rule. And then ideas around foreseeability. Is the impact that was felt just too far distant from the actual conduct? You do have to convince courts of both factual and legal causation to make out tort causes of action in particular. And that I'll end on that. So again, thank you very much for inviting me and listening to this, and I look forward to your questions. Thank you.
Thank you very much, Hassan. So we just go directly with the next speaker, Professor Danielle de Andrade Moreira, who is an associate professor at the Pontifícia Católica University of Rio de Janeiro. And she's also the founder and coordinator of the Law, Environment and Justice in the Anthropocene research group, which you may know as JUMA. A great publication from them, and we use a lot of their materials. So great. Thank you very much for this. And she's also serves as director of the Law for Green Planet Institute and academic coordinator of the Association of Environmental Law Professors of Brazil. And she's now part of our project as the National Rapporteur for Brazil in the Toolbox project. So thank you very much, Dani, for being with us, and the floor is yours. Thank you again.
Thank you, Ivano. Thank you. Good morning to all of you. I'm very happy to be here to join you in this conference. I'd like to thank Ivano and Michael for the invitation. It's also a great pleasure to share this session with Jarryd and Hassan, and to have the opportunity to bring some ideas and some information about corporate climate litigation in Brazil. So Ivano said that I coordinate a research group called JUMA, is the nickname, it's JUMA, and we are responsible for developing and maintaining the Brazilian climate litigation platform. It's a database that gathers information about climate litigation cases in Brazil, and we are happy that we have the opportunity to feed the Sabin Center's platform with Brazil, with information about Brazilian cases. And I'll share my slide. They already here. I have 15 minutes. This is the roadmap. I'll start with a quick overview about how Brazil fits within the world climate litigation scenario. And then I'll talk a little bit about the climate litigation, Brazilian climate litigation profile, but focusing on, of course, on corporate climate litigation. And when focusing on the main trades and of this specific type of cases. And to finish, I'll bring some ideas and about the key trends and emerging patterns for the development of this topic in Brazil. So we have seen a few of this number before. We have Brazil, we have like more than 3,000 climate cases reported globally. And although we see that they are concentrated much more in the global north, in the global south, we're seeing a growing number of cases being brought, and Brazil is in the 3rd place now, as the jurisdiction in the global south with the highest number of cases, and also is the third country in the world with the highest number of reported cases. And it's growing. We now have 128 lawsuits cataloged, registered in the platform. We always have a few cases being analyzed, so in a few months we'll have like more than 130, and we never stop and analyzing new cases. We have launched this platform in August 2022 with 50 cases, and now we have 128 cases cataloged. This is the link to the website, to the platform. As I said before, it is dedicated to gathering information on Brazilian climate litigation cases. We have the goal as an academic, a research group, to not only to disseminate information that enables research and action to fight against social, environmental, and climate injustice in Brazil. And climate justice is a cross-cutting topic for us, but we also want to produce analysis about the profile to see which arguments are being brought or could be brought in the cases. But we do have, as Jarryd said, something about the concept, the different definitions for climate litigation. We have this limitation. We had to limit our scope when we were developing the platform. So we intentionally do not include indirect climate cases. No. Although we, particularly in Brazil, we have the right to a stable environment provided as a human right, as a fundamental right provided by our constitution. And we have a long history of development of environmental law and environmental litigation in general. Many of these cases, they are important also for climate. Deforestation cases, for example, they could be all of them classified as climate cases, although they not expressly mention climate and GHG emissions. But of course, it wouldn't be feasible to build a platform with all the cases, and we would not be able to analyze the specificities and particularities of direct climate cases. So we decided to limit the scope of the platform, and we include cases in have two different approaches, cases in which the climate issues is a central issue or one of the central. This is something that's interesting about Brazil. Sometimes it's not easy. Sometimes we don't find a case that's only about climate. Mm. Climate always comes together with other environmental topics. So climate might be one together with others, one of the main issues of the claim. But there are other approach that we found interesting to include, that the climate approach, when climate concerns are brought to the case as we call contextual argument. So it might not be the central issue, but it's something that brings context, and those cases, they have to mention climate change, to mention GHG emissions, one of these expressions. But we found them very important to see how climate is being dealt by the courts and how it's being brought to the analysis by the judicial system. And we developed a methodology to classify the cases, to analyze the cases. And these categories allow us to identify parameters and to develop this analysis on Brazilian climate litigation peculiarities. These are the bulletins and reports we have already published. The bulletins, they bring a more quantitative analysis and an initial qualitative analysis, but we have just one report that brings an in-depth analysis on the cases. It was published in March 2024, when we had 80 cases, and now we have 128 cases. But we have this bulletin published last December, analyzing the 120 cases we had back then in the platform. This is how the platform looks like. We only have it in Portuguese until now, but we are working on developing a translation, automatic translation. So in a few months, we'll have everything in English and in Spanish as well. This is an overview of the timeline. We can see in this graphic that after 2018, 2019, there is an increasing number of cases in climate cases in our judicial system. Those earlier cases, it seems interesting to see the different patterns of those cases. The earlier cases were typical environmental litigation cases in which climate was not mentioned in the claims. Climate appeared in a high Superior Court of Justice decision when dealing with air pollution, with water pollution and forest code, and the tribunal brought the climate issue as an important issue together to be analyzed and to be considered together with other issues, other environmental issues. So we could not let them, and we had to include those cases that brought the climate issue in the final decision sometimes, but they were not brought as climate litigation cases. So there's a difference between those earlier cases and the most recent cases filed, especially after 2018, 2019. Those cases started bringing the climate issue as a central issue, as I mentioned before, or even if as a contextual argument, but with much more in-depth analysis and developing the climate concerns in the complaints and also in the decisions, but they were brought to be climate cases. And it's something it's interesting to note as well, is that climate litigation in Brazil comes together with environmental litigation. It's impossible to segregate those. Although we do need to see the peculiarities and specificities of climate litigation and climate concerns, they bring much more challenges to the environmental litigation, the general environmental litigation, but it's a branch, it's like a subdivision. And our National Council of Justice had already said that climate litigation, we have a resolution about the judiciary political practice on environment. I don't remember exactly the name in English, but climate litigation is a subject of environmental litigation. So it's not something that comes a part of it. This is to have an overview about who is bringing those cases, the types of plaintiffs. We have the Federal Public Prosecution Office as and together with the cases brought by the State Public Prosecution Office, we have the main protagonist of environmental litigation. But in climate litigation, we can see that public administration bodies, like our EPA, our Federal Environmental Agency and other federal agencies, together with civil society, with NGOs, they are bringing cases. Although they had already standing since 1981, when our Public Civil Action Act was enacted, we didn't see that before. They didn't have the tools or the capacity of bringing cases. They didn't act that much as litigants, but now they do. So it's something that comes, it's a peculiarity of climate litigation that we didn't have in, and we didn't see in environmental litigation in general. In terms of types of defendants, and here we can see the corporate, the companies, we still have the majority of cases brought against the government. I mean the public sector. We have many different types of categories that are encompassed, but what we call, what I can say here, a public sector. But we have been seeing a growing number of cases being brought against companies. And sometimes those cases brought, especially cases about on environmental licensing procedures and challenging and saying that there were flaws in the environmental licensing procedures, they are brought against companies, but together with the public sector, together with the environmental agency. So we have like this diverse type of defendants in some corporate cases. And we have been seeing a growing number of cases being brought against individuals. Those are small, not that small, but smaller cases on deforestation against individuals. But then sometimes we have like small companies being sued for that. They are much more individuals than companies. I mean, they are like really, really, really small companies. So sometimes it's not easy in terms of, especially when we're talking about deforestation cases, to divide cases brought against companies and against individuals. They are almost the same arguments and the same everything. In terms of the types of actions, we can see here that we have 90 cases that use the public civil action. That's the procedural tool we have in Brazil since 1981. But if we sum up the constitution of the set of constitutional judicial review actions, we have 21 cases. Those constitutional cases are brought directly before the Supreme Court, and most of them, not all of them, but most of them are cases that were brought during Bolsonaro government to try to refrain to challenging the setbacks that we were seeing back then. We have I'm not going to show you all the categories. We have just a few of them. We have this classification. We divide the cases. The case can be either systemic or routine. Systemic cases are those cases that seek adjustments, structural adjustments and changes in public policy or private policy. So we have those cases against setbacks, are most of them systemic cases. And we have the routine cases, the cases that deal with a specific project or activity. They are more like routine litigation, but they are very important. I mean, they can be used after, when you have many routine cases, they can be replicated to and change a way of modus operandi, a way of working of a specific sector. For example, those cases about climate damage, cases about environmental licensing as well, they can be replicated and they can induce a change in the whole sector. So they are, although they are not sexy cases, they have this potential to be replicated. We have, in the systemic cases, we have it's a set of cases with a more not that diverse, a more, we can understand the profile easily. Cases they usually are fighting setbacks, the use of constitutional arguments and constitutional actions. we have, for example, that's a number that stands out. We have 43 systemic cases, and 32 of them were filed between 2019 and 2022, the years of Bolsonaro government. So this is peculiar. And we have routine cases. Most corporate cases are routine cases. And those cases, they deal with a variety of issues. It's not easy to find a specific profile of these cases. They can deal with different kinds of issues, but we can see a few of recurrent issues bringing in these routine cases, and two of them are civil liability for climate environmental damage and environmental licensing as well, and cases brought mostly against companies. In terms of greenhouse gases emissions, the sector which are being challenged in the judicial system, we have land use change and forest as the main sector. And this is something that we can understand, considering the profile, the GHG emissions profile of Brazil. In Brazil, we have around 48% of our emissions are from land use change, and around 28% from agriculture and cattle raising. So, of course, we would have this profile cases challenging land use change and forest, but we are seeing a growing number of cases being brought, cases that deal with the energy sector, especially cases about environmental licensing procedures, and also industrial processes. And in terms of the measures addressed in the cases, mitigation is the measure most addressed, but we are seeing, again, a growing number of cases about in which the measure addressed is related to civil liability for climate harm, and also climate risk analysis. So every category, every niche classification we have brings us to civil liability for environmental damage and to environmental licensing procedures. This is how our report looks like. I am not the author of this report. Caio Borges developed the report. I have just helped with me and the other co-rapporteur, Carolina Garrido. She's a researcher in JUMA research group. We have just helped with the executive summary. And I'm very, very happy to join the team. We can see, so some information that I will bring in the second part of the presentation. We can see, you find in the report, and there is something new findings that's interesting to see them. We have a growing number of corporate climate litigation in Brazil. Now we have 35 active cases targeting companies. And those companies, which companies? Companies that are involved in deforestation, in other high emission activities, especially in the energy sector, especially coal-fired plants and coal mining. These cases, this is something important. It's one of the main takeaways. The cases draw upon established legal avenues. For more than 40 years of environmental law, development, environmental litigation, we are using the same tools that we already had. Just we're bringing the climate issue to see it through another lens, like to see the specificities of the climate issue. And most cases are brought by the Public Prosecution Office and also civil society. That's something particular for us, new for us. We have among the defendants, timber, energy, and mining companies accused of promoting or contributing. We have a broad notion of polluter that includes indirect polluters in Brazil. So they might only contribute to deforestation, and also companies being accused of non-compliance with environmental litigation, regulations, flaws in environmental licensing process, for example. And the vast majority of those cases brought against companies are routine cases. So they focus on a specific project or a specific activity. And as I said, we replicate strategies and arguments that were already being employed in general environmental litigation. So to see the most recurrent topics in climate litigation against private sector. And here I include individuals, especially in cases about 2 minutes.
2 minutes.
Environmental civil liability and environmental licensing. I'll skip this and go straight to the civil liability. So we have 53 lawsuits based on civil liability. We have, I won't have the time here, but we have peculiar traits in our environmental civil liability in Brazil. They are peculiar, they are different from, we have strict liability, we have absolute risk liability, we have another way of seeing the causation with much more flexibility. We have the direct and indirect polluter, but I won't have time to talk about that today. But we also have this preventive function of the civil liability. Civil liability arguing for measures to be addressed for preventing future harms. So we have this view to the future and view to the past. We have, and I have to condense here, not to keep on going about the streets, but we have those restorative and preventive dimensions in civil liability, and those dimensions are being brought in those cases, deforestation cases. And we also have what we call a multifaceted nature of environmental damage. So environmental damage in Brazil has many dimensions, and climate is one of the dimensions of environmental damage, and that's the way we are dealing with climate damage in Brazil right now. We have cases, in some cases, the climate dimension of the environmental damage is developed more in a more deep way. In other cases, environmental damage is, they don't say much when they are asking for the compensation for the environmental damage, but they do demonstrate the damage, also considering the GHG emissions, for example. We have, among this 53 cases, we have 39 cases that explicitly develop the climate damage argument. We have been seeing different methodologies for valuing this climate dimension of environmental damage. The main issue being brought to the courts is deforestation. It's the most questioned pollution activities. We have one case that it's a new case. It's interesting, that challenges environmental licensing of a coal-fired power plant, and they are arguing, they are using both ways, both cause of actions, environmental licensing regulations. The licensing of the power plant was not, well, has many flaws, and because of that, the emissions, the GHG emissions, were not considered, and they became a harm, a climate harm. So they have to be repaired using all that we have in terms of civil liability for environmental harm. And something interesting as well, these lawsuits, especially suits about deforestation, they can be brought against deforestators themselves, like direct polluters, but also those responsible for other activities in the deforestation chain, indirect polluters. So those who keep in deposit, for example, timber from illegal deforestation, they are responsible together, joint and severally, with the direct polluter. And many of these cases are against those that have timber in deposit. And I'm finishing just a few words about licensing. We have 16 lawsuits that address directly environmental licensing with the climate issue as a cause of action or a claim. We have been seeing these cases, particularly in the south of Brazil, the state of Rio Grande do Sul, and a case in Paraná. They deal with the energy sector of emissions of GHG, and they are related to projects related to fossil fuels, coal extraction or coal-fired power plants. And something interesting, we see in those cases, the climate issues being brought together in association with other environmental impacts, like air pollution, water issue, participation of affected populations, consultation with indigenous peoples, etc. And that's, I swear that's the last one. Perspectives. We have been seeing already, and I think we'll keep on this trend for the next, at least until the end of next year. Now, reduction of systemic cases brought against the federal government. We had many of these type of cases during between 2019 and 2022, and then there's a reduction. We have been seeing increasing litigation against the private sector in general, increasing number of cases related to environmental licensing and civil liability for climate environmental damage. We don't have yet, but I think we're going to see them cases that are related to climate disasters. I mean, civil liability for climate environmental damage related to climate disasters. We call like indirect climate damage. And we can also say that's just to finish, to wrap up, in terms of how the profile of corporate climate litigation in Brazil, a consolidation of the strategic use of foundational and long-standing environmental law in corporate climate litigation. So we have climate litigation in Brazil, and also corporate climate litigation in Brazil builds upon over 4 decades of environmental law development and litigation practice. We use the same foundational legal principles and long-standing procedural tools to they serve as a legal toolkit for corporate climate litigation. I've seen that these instruments are being reinterpreted and applied in light of the specificities of climate change. Sorry, I was like running out of time, and I know that my English is not that good. I hope I could express myself.
Thank you very much, Dan. It was great, and a wealth of information. And yeah, the Brazilian legal system is really like super interesting for analyzing what kind of direction we're taking around the world. And it's especially in Brazil, it's really important to consider this as a fundamental key part of the climate governance. So no, it was absolutely sorry that we didn't allocate more time for that, but as Danny said, there is a national reports there. You can go and also see the work that she and her colleagues at JUMA have done, and really it worth the reading. So I would say, without further ado, if you have any questions, so we open the floor to the audience. If you have any question about this, because we know that we are a little bit late, but yeah, if you have any question before taking just a little break. So do you have any question for our speakers? I think that this was, yeah.
Yeah, so Danny, thank you so much for the presentation. One of the things that you mentioned was that the cases brought by civil society are newer in Brazil. Could you talk about that a little bit more, about what those cases are and maybe how they sit in the context of what you're seeing in some other countries as well?
Sure. As I said, civil society already had standing for bringing those cases since the 1981, based on the Public Civil Action Act. But in terms of environmental litigation as a whole, in general, we didn't see NGOs as protagonists in bringing those cases. They didn't have the capacity installed to follow a case from the beginning, to building a case from the beginning to the end. But we have been seeing a strengthening process of civil society also in Brazil for climate issues, in terms of climate, not only climate litigation, but for climate action, I would say. So I think we have this specificity. NGOs in Brazil that work with climate, they have the capacity of bringing those cases. They are, for example, helping public parties to bring cases. So part of the cases that we see here, I don't have the numbers here in my head, but are brought by public parties. These systemic cases against that are brought directly in the Supreme Court. Those public parties, they are officially, but NGOs worked to help building those cases. So the numbers are even higher. And in terms of corporate climate litigation, cases that, those set of cases about environmental licensing processes, they are much more brought by NGO. There's much more than the public prosecution office, for example. So we see that this pattern, deforestation cases are being brought much more by the public prosecution office, and environmental licensing disputes being brought by much more, not only, of course, but much more by civil society.
Any other questions? Yeah, please.
Yeah, my question is also to Danny. So I found it really fascinating that that Brazil is ranked third in the world for climate change litigation. So the US, not surprised, right? Very litigious state. Australia, very, very active group of environmental scholars. What's special about Brazil, and are there lessons that the rest of us can learn from?
Actually, I'll be honest with you. I don't think, I think we have because of, we are working to find those cases. So we have the capacity of reporting those cases. I think that's one reason. Many other countries, they don't have a platform for their cases. They don't have groups studying and with this purpose. This is a simple answer, but I think that means a lot. Jarryd said something about the capacity of reporting. I don't remember exactly.
Data collection.
The data collection. They might be underestimated.
Yeah.
And in Brazil, we are working. We have like 6 people just trying to find those cases. This, of course, this is not the only answer, but this is one factor, the capacity of finding cases and analyzing those cases. But we also have this, as I said before, 40 years of development of environmental litigation in general. So I usually say that what we use the environmental litigation like as a shortcut for climate litigation, because we already have those legal avenues paved for climate litigation. So we have these opportunities. That's why another reason. One is more simple reason, but this one I think it's more consistent. Where we have a fertile ground. I use this expression. I don't know if it's a good expression in English, but a fertile ground for climate litigation. And this ground is being fertilized because it's fertile. Yeah. So that's something in terms of the foundations we need to bring those cases.
Yeah, and let's hope this will help us also cross-fertilize other jurisdictions. Yeah, please.
So how successful have these cases been, and is the difference between the public prosecutors, the NGOs, the winning more, or the combination that you talked about where they're working together?
Actually, it's not easy now to talk about. We have just a few cases concluded, but we do have a extensive case law on environmental legislation based on civil liability and environmental licensing, those most recurrent topics in climate litigation as well, that says to us that we might be successful in those type of cases. But what I mean, I know I'm not answering exactly what you asked, but going to your question, I don't think there's a big difference between, or different chances of winning in cases brought by the civil society and the public prosecutors. I think it depends on the arguments, on how solid and how already tested are those arguments. And we have in both recurrent types of cases, solid case law that can be. So I think the difference won't be who is bringing the case. I don't know if my friend Gabriel, the federal judge, is going to talk after in the afternoon. I don't know if he agrees with me, but you can. With you. Yeah.
Another question, please.
I was about cases that involve greenwashing in Canada, the US, and Brazil. Is that a fertile ground? I understand there have been some wins in Canada, although not mentioned. But I know that there have been cases even about greenwashing for corporations that are Brazilian corporations in the US. So I'm just interested, is that an area where are you seeing successes? Are there differences in the different jurisdictions? That's one question. And then I just have a second question around methane. I know maybe there are issues with how what is a climate litigation case or not when it comes to agriculture, etc. But are there cases that look at methane as a gas in any of the jurisdictions?
I'm happy to address the greenwashing in Canada. So I'm speaking about this tomorrow morning. So do try to attend that panel if you're able to. You know, in terms of successes, I wouldn't really say there have been any kind of major successes. And then the other part of this is these are not necessarily court cases, but we do have tribunals who do have jurisdiction to consider these kind of claims. So we have claims that have been brought in, for instance, the competition tribunal, pursuant to claims made by banks, for instance, or insurance companies. But I can't really think of any major success when it comes to the courts in looking at these claims. There have been some attempts to bring claims against airline companies for their assertions around being net zero. But again, there's been nothing brought in the courts so far. So, all in all, this ties to what I was mentioning in my presentation. When it comes to the corporate side of things, Canada has been, as compared to Brazil or the US or the Netherlands, more conservative in this regard in terms of using the laws that are already there to bring corporate climate cases. And I think greenwashing is very similar. There's potential theories out there, but nothing's really been brought to the courts.
I just add briefly for the US perspective, something very similar, right? I know there was a DC case that was brought against Coca-Cola that was eventually dismissed because the court found that Coca-Cola's claims weren't sort of binding promises. They were just aspirational claims. There is an ongoing lawsuit right now, a class action suit against Evian for claims about their carbon neutrality. And so sort of we'll see how that one plays out, but I similarly can't think of sort of any big high profile greenwashing cases where the plaintiffs were successful in the US.
I would say the same in Brazil. I don't think we have a case about greenwashing yet. I might be wrong because when we launched the platform, I knew all the 50 cases, but now we have 128. I don't know. But actually, not remembering of a case about greenwashing, I think I would know. But we don't have it. Although we have a consumer law that's also developed and can be mobilized for together with environmental regulations, but we still don't have any case. Do you know, Gabriel, if we have? No.
And actually, this is the kind of cases that around the world are, skyrocketing. So in the last years, greenwashing cases are really multiplying everywhere in the world. And we had also some interesting decision, like as usual in the Netherlands with the KLM case. So I think this would be also something potentially interesting. But as we said, in each legal system, it's quite different. So it depends also on how we are approaching them through consumer law. Could be also something else, could be also something related to fraud claims, be something also related to tort sometimes. So this is also something that is interesting about this toolbox, and the kind of research you can do about it is the fact that you can really take stock of what the legal system itself can provide and trying to, let's say, create a sort of bricolage. And so learn something from other experience and trying to bring your own legal system. So maybe we will have something also, positive in the Americas. And I didn't say, but you will see this is just the first panel. And in the next ones, you will see other experts from Brazil, from Canada, from the US, and also from other countries, from Peru, Chile, Mexico, which are the new countries that we're adding to the toolbox. So this is just to say that probably we can also close here because we are already very far behind. But thank you very much for your questions and see you in 15 minutes. Yeah. Thank you very much, everyone.